Good evening, friends. Welcome you all to StudyIQ IAS English. This is Vishal, Faculty of Law Optional and Indian Polity at StudyIQ. Students, in today's video, we'll discuss the issue of phone tapping. All of you must be aware of the phenomena of phone tapping. Now, generally, phone tapping, you must have heard about it in movies or in any sort of web series. You must have also heard about it if you have followed any criminal case. Now, what is phone tapping? See, phone tapping generally means when an external body, for example, a police authority or a hacker is monitoring your phone conversations. If a person who is not authorized by you, if that person is monitoring your phone conversations or any sort of your usage of electronic communication, that means the person is tapping into your electronic devices. Now, the question here is phone tapping constitutionally valid in India? Because if we ask about right to privacy, or if we bring in the right of privacy into this particular concept, we will feel that the court in multiple cases, for example, case Puttasamy versus Union of India, has clearly stated that every person has a right to privacy. Right to privacy is an intrinsic part of right to life. That means the state cannot violate your right to privacy until and unless it follows a procedure established by law. And on the other hand, phone tapping sometimes become essential for enforcement of law, because in case of certain criminals, the police or the law enforcement agencies, they take help through phone tapping. They try to find about the whereabouts, or they try to find about the plans that or conspiracies that are being hatched by criminals, so that they can burst the plans and they can nab the criminals. So on one hand, phone tapping constitutes a right to privacy of individual. On the other hand, phone tapping sometimes becomes essential or important for the purpose of law enforcement. So now the thing here is phone tapping in India legal? And if it is legal in India, if the state or authorities of the state are allowed to tap your phones, to what extent? Or under what circumstances only can they tap your phones? Now in today's video, we're going to discuss all the important elements related to phone tapping. See, I told you what is phone tapping. Now this is a definition of phone tapping. See, phone tapping generally means it is the monitoring of telephone or internet communication by a third party. That means a third person, he is monitoring whatever you are transmitting through your phone. If you're talking to someone and any third person is listening to whatever you're talking, he's listening to your conversation, that means he's tapping your phone. Or if any person is also tapping into the data or messages that you're transmitting from your electronic devices, he's also tapping into your electronic devices. Now, it can be conducted by authorities, I told you, for the purpose of law enforcement. And it can be conducted by hackers, obviously, for the purpose of intruding into your private space. Now, the question, the constitutional that comes into existence or picture is whether the tapping of phone of individuals by law enforcement agencies violate the right to privacy, or under what circumstances and to what extent tapping of phone is permissible. Now, this is related to right to privacy, right to life, and restrictions on, or we can say the limitation on right to life. Now, we're going to discuss this topic with the help of a particular case. Now, the name of the case was P. Kishor versus Secretary to the Government of India 2025. Now, I will tell you the facts of this particular case. The facts are quite interesting. You will be really interested in finding out the facts. Now, what happened? There was a company by the name of Avron Education Limited that was based out of Perungudi, Chennai. There was a company, the name of the company was MS Environ Education Limited, that was based out of Perungudi, Chennai. Now, this company had a tax liability. That means the company was making profits and it had to pay tax as per Indian Income Tax Act. But the company was evading taxes. Now, an assessing officer, obviously, who was an IRS officer, his name was Mr. Uttam Bora. Now, this Now, the name of the IRS officer was Andasu Ravinder. Now this IRS officer, he raided the premises of this particular company. He raided the head office of that particular company. When he raided the head office and he found out the relevant documents containing the accounts of and the profits of the company, he got to know that the company had a huge tax liability. That means the company had to pay taxes as per the provisions of Income Tax Act, but the company was not paying. Company was evading. Now, as per law, the assessing officer, obviously the IRS, Indian Revenue Service officer, understood Ravinder, he had to invoke the provisions of law and he had to take all the legal actions that were necessitated as per the law. But it took the other way around. Now he asked for a bribe. He told the accused, that you have a huge tax liability, and if I institute legal proceedings against you, now you will be under trouble, because you have to discharge the liability and you can also be criminally prosecuted. So that's why it would be easy for you if you give me a bribe. If you give me a bribe, obviously I will discharge your name and I will ensure that no legal proceedings are instituted against you. And the accused, he agreed. Obviously, giving bribe seemed to him to be much easier rather than getting entangled in legal proceedings. So he had agreed. And the plan was that the MD, managing director of this company, he will pay 50 lakh rupees to this IRS officer in lieu of the IRS officer not initiating any legal proceedings against him under law. Now this plan was hatched. Somehow CBI got to know of this particular plan. Somehow CBI, the Central Bureau of Investigation, got to know of this particular plan, and they wanted to tap the phones of this IRS officer and this managing director so that they can get clear-cut information about the time when this IRS officer would be receiving the bribe, because CBI wanted that they will nab them, they will raid the premises and they will get them red-handed. So now CBI wanted to tap the phone, so that's why CBI requested, Central Bureau of Investigation requested the Secretary to the Government of India to issue an order under Section 5 subsection 2 of the Telegraph Act. The Telegraph Act. Now the Secretary to the Government of India issued an order, and on the basis of that order, CBI tapped the phone. As they tapped the phone, they get to know of the details of the conspiracy, and as per the details, they raided the premises where there was exchange of bribe, or where the bribe was being given and at that particular time. So as they raided the premises, so they got the IRS officer as well as the person who was giving the bribe, they caught them red-handed. When they caught them red-handed, obviously they filed legal proceedings under Prevention of Corruption Act as well as criminal conspiracy, because IRS officer was taking bribe and the director of company, he was giving bribe. So both of them were guilty. So they booked them under relevant provisions of Prevention of Corruption Act. But the thing here is, there was a twist. The director of the education company, he filed a petition in the court and he said that as CBI has tapped my phone, now phone tapping is unconstitutional, illegal, because it is violating my privacy. So that's why any information that was received out of the phone tapping, it cannot be admitted in court of law. It cannot be relied upon. Now the question before the court was whether the phone tapping conducted in this particular case, was it legal? Was it not a violation of privacy? Now the court conducted analysis of the law. Now in India, phone tapping can be done as per the provisions of Section 5 subsection 2 of Indian Telegraph Act 1885. Section 5 subsection 2 specifically states that the central government or the state government, that means either central or the state government, they can issue orders for phone tapping, but only on certain conditions. For example, in case of public emergency or in the interest of public safety. Section 5 subsection 2 of Indian Telegraph Act specifically states the central government and state government, they have the power to issue orders regarding phone tapping of any individual, but only for the purpose of public emergency or in the interest of public safety. That means the government can only issue orders if these two conditions, any of these two conditions are fulfilled. Or if there is a threat to sovereignty of India, security of the state, friendly relations with foreign state, public order, or if the government want to prevent commission of any offense. So the government can issue an order, and on the basis of that tapping order, the government authorities can stop the transmission of any message. Now, for example, if I sent any message and my phone is tapped, the government authorities, by phone tapping, they can stop the transmission of message. For me, it would be like I have transmitted the message, but the message would not be transmitted. It would be intercepted somewhere in between. Secondly, the government authorities, under the phone tapping orders, they can also intercept the messages that have been delivered. So that means under phone tapping, the messages that have been delivered by the person whose phone is tapped, the messages can either be stopped from transmission, or they can also be intercepted. They can also be intercepted and disclosed to the government. That means now your messages are open to the government. But there is a certain safeguard. I told you, phone tapping orders can be issued by either central government or the state government. One, only on either if there is a need for public emergency or if there is threat to public safety. Two, now the thing here is, who can issue orders under the government? Because the government, obviously, it's a large institution. So rule 419A, subsection clause A, subclause 1 specifically states that orders of phone tapping, it can only be issued by either the Secretary to the Government of India in Ministry of Home Affairs, or the Secretary to the State Government in charge of Home Department, or any other officers in case of emergency. That is authorized by both of them. So in government, who can issue orders of phone tapping? Either Secretary to the Government of India in Home Ministry, either Secretary to the Government of State in Home Department, or any other officer in case of emergency as authorized by these two officers. That means no officer or none of the officers other than these two officers can tap the phones or issue orders for tapping of the phone. Now, this is a very important safeguard. This is a very important safeguard because in movies you must have seen that a police inspector or a constable is tapping the phone. He cannot do it. He does not have the authority to tap somebody else's phone until and unless the orders come from Secretary to the Government of India or Secretary to the State Government in the Home Department. Now, this is one safeguard. Now, there is a second safeguard. As tapping of phone, obviously it is violation of privacy of an individual. So that's why there is a second safeguard. Now, what is the safeguard? The safeguard simply says, as soon as the phone of a person is tapped, information is intercepted by the authority. Now, within a month of interception of these messages, a review committee will be formed. Now, who will be the member of this review committee? The members of review committee will be Cabinet Secretary. Now, Cabinet Secretary, he is a highest ranking IAS officer. And two secretaries to the Government of India in the Department of Legal Affairs as well as Department of Telecommunication. Now, these three people, they will oversee whether the phone tapping order, they were issued strictly in compliance with Section 5 of Indian Telegraph Act. Secondly, if the orders were not issued strictly in the compliance of Section 5 of the Indian Telegraph Act, then the review committee can destroy the copies of the information or intercepted messages. So that means the review committee will ensure there is no misuse of the phone tapping provisions under Indian Telegraph Act. Now, this is a second safeguard that has been made in the favor of common man. Now, there is a case, the name of the case was Gobind versus State of Madhya Pradesh. The court in this case specifically stated that right to privacy, it is a part of right to dignity. Right to privacy is a part of right to dignity. Obviously, that means it is a part of right to life. Now, this right can only be taken away, or this right can only be violated if there is a compelling state interest. That means if the interest of the state, or people at large demands that a right to privacy of somebody shall be violated, only in that condition the state can violate right to privacy of any person. If there is no compelling state interest, if there is no reason for violating the privacy of an individual cannot be violated, because it is as important as right to life. Now there is a very important case. The name was People Union for Civil Liberties versus Union of India, PUCL. In this particular case, the court specifically dealt with the issue of phone tapping and the violation of right to privacy. The court simply stated, whenever a person is talking on a phone, obviously he does not expect somebody else to listen to him. Suppose you are talking on a phone, you do not expect somebody else to listen to you. You also do not expect somebody else to intercept your messages, because generally the phone conversations, the telephonic conversations, they are of private nature. So when I'm talking on a phone, I do not expect any person to listen to me, nor do I expect any person to intercept what I am transmitting or what I am saying or listening. That means telephonic conversations is also a part of right to privacy. The court said conversation on telephone, they are of intimate and confidential character. That's why they are a part of right to privacy, and every person has a right to privacy with respect to conducting telephonic conversation in the privacy of their house. If phone is being tapped, so that means it is violation of Article 21. And if violation of Article 21, right to life, has to be done, it can only be done by on the strength of procedure established by law, because Article 21 simply states none of a person can be deprived of his life and liberty unless as per procedure established by law. So that means if a phone of a person has to be tapped, that means if his privacy has to be intruded, it can only be done as per procedure established by law. Now, what is the procedure established by law? The procedure established by Section 5, Subsection 2 of Indian Telegraph Act, as well as the Indian Telegraph rules. So these rules, this rule. Secondly, this rule. Rule 419, Clause A, Subclause 1, Rule 419A, Clause 70. Now in this particular case, the court specifically stated that Section 5, Subsection 2 only allows phone tapping in two circumstances: if there is a public emergency, or if there is a compelling state interest in the form of public safety. Now, what is public emergency? Public emergency means generally any situation or sudden condition that can affect the large number of people. Public safety generally means that the risk that large number of people are at risk. So public emergency means that when interests of large number of people are at stake. Public safety means when the safety of a large number of people are at risk. Only in these two conditions, the government can issue orders for tapping of a phone. That means if none of these conditions exist, the government cannot issue orders for tapping of a phone under Section 5, Subsection 2 of Indian Telegraph Act. Secondly, the court said it is also essential that the procedure has to be followed by review committee. It shall be strictly followed. Only if all of these conditions are met, only then the government can issue phone tapping orders. Now, in the case, P. Kishor case, now what do we think? What would be the judgment of the Madras High Court? The court said that we have been guided by Supreme Court in PUCL, People Union for Civil Liberties case. In that case, court said telephone tapping, it is violation of right to privacy. If it is violation of right to privacy, it has to be conducted strictly as per provision of law. What is the provision of law? The phone tapping can only be done only in the interest of public emergency, only in the case of public emergency or in case of public safety. Secondly, orders can only be issued by secretaries to the Home Department. Thirdly, a review committee has to be formed that will decide that whether telephone tapping orders have been strictly issued or not. If none of these conditions are met, phone tapping, it would be unconstitutional. So in this case, the court said, in particular case, the matter was regarding acceptance and giving of bribe. That means it was not a public emergency, neither it was in the interest of public safety, because accepting and giving of bribe, I'm not saying it is not an offense, it is a serious offense, but it is not that serious that will impact the public safety or it will be counted as public emergency. One. Secondly, the court stated that the requirement of review committee will study whether the phone tapping orders were strictly issued as per law or not. That was not also followed. So that means section 5 subsection 2 of Indian Telegraph Act was violated. The requirement of review committee was also violated. So that means this phone tapping order, it was not valid under Article 21 because it is violating right to privacy but not following the procedure established by law. So the court said in this particular case, the interception order was unconstitutional. So all the data or all the information that police has gathered through phone tapping, it has to be destroyed. So now in this particular video, we have understood what is needed to understand phone tapping. Under what circumstances the court can go for phone tapping, under what circumstances the court can authorize or the government can authorize the tapping of a phone. So I hope with this video, all your doubts regarding phone tapping, right to privacy would have been cleared. For more of such videos, please stay connected with StudyIQ IAS English. Thank you.